Cybersquatting in Australia. What is cybersquatting? Cybersquatting is when a party registers a domain name they have no rights over. For example, imagine if someone purchased domain names that are so similar to your business in an effort to redirect internet traffic away from your site, perhaps losing your money. In order to rectify this problem, businesses have offered to buy these domain names from cybersquatters, but at a grossly inflated price. In L'Oreal Australia Pty and Namewise Pty Ltd 2013, L'Oreal made a complaint against Mr. Nicholas Bolton of Victoria, Australia, who had registered the domain name www.l'orealstore.com.au. The domain name was diverting potential customers of L'Oreal to Mr. Bolton's website. What are your options? In Australia, the presence of cybersquatting is not as prevalent as in other jurisdictions, mainly due to the stringent domain name registration policies. Domain names are required to be close to the registered name of the organisation seeking to register. Australia has currently no legislation pertaining specifically to cybersquatting. There are a few options for seeking remedies from cybersquatters in Australia. Firstly, if you do not wish to seek a court remedy, you can resort to dispute resolution. Secondly, a plaintiff can seek remedy under the provisions of the Trade Practices Act 1974, Commonwealth. Dispute resolution. The World Intellectual Property Organization developed the Uniform Domain Name Dispute Resolution Policy, the UDRP, which is a three-stage test to resolve disputes between domain name registrants. The AUDRP is utilised in Australia and closely reflects this. The process is overseen by an independent administrative panel of mediators who apply the .AUDRP test and international intellectual property principles. This was applied to in the L'Oreal case mentioned earlier. In the Sydney Flower Market case, the applicant and the respondent both had similar domain names. The applicant had registered sydneyflowermarket.com, sydneyflowermarket.net, and sydneyflowermarket.net.au, while the respondent had registered sydneyflowermarket.com.au. Section 52 of the Trade Practices Act was applied, and it was established that neither parties had misled or deceived the public. Due to the amount of evidence both sides presented and the establishment of the businesses, Justice Healy decided that both the respondent and the applicant were to provide disclaimers on their websites, directing the public to ensure that they were at the correct web address. How can cybersquatting be prevented? One of the ways businesses can protect themselves from cybersquatting is to ensure that when registering your domain name, a number of similar names are also registered. For example, any variations of the business name or possible misspellings of the domain name. However, this does not have any effect if the domain name has been taken hostage by a cybersquatter already. In the US, there are legislative measures in place to combat cybersquatting. The Anti-Cybersquatting Consumer Protection Act of 1999 provides that a person will be liable in a civil action by the owner of a trademark or service mark. Further, Section 4 allows for the plaintiff to recover not less than $1,000 and not more than $100,000 in statutory damages. Adopting a similar legislative position in Australia would effectively deter these netrepreneurs from profiting from cybersquatting. As the availability of domain name has decreased over time, the prevalence of cybersquatting may increase. Having a legislative solution would be the first step in tackling this issue.